Hello again, I'm Jo from NaviStar Legal. Thank you so much for joining me and welcome back. In this video, we're going to address the key things that you want to do when you have a complaint from your clients. As you may already know, this is our last video in our three-part series. I hope that you've enjoyed what you've heard so far and that you've been able to take action on it immediately. In our first video, we looked at mistakes that businesses like yours can make, whether it's to not get signed agreements, getting legal advice too early, or not storing documents properly. In our second video, we went on to cover the 3 key terms that you must have in your one-to-one coaching or consultancy agreements. Now, this video is all about what to do when it all goes wrong. It may also be useful for you if you've ever fallen foul to dishonest or perhaps overzealous trainers yourself. Some people in this industry promise the world to cure your cancer, remove your depression, or allow you to become a millionaire in a year. And then somehow they fail to deliver and walk right out without care in the world and keep your money firmly in their back pocket. Every company wants to prevent complaints, disputes, or litigation, but they do happen and they can take up valuable time, money, and energy when they do. So let's start with the fact that it can all go wrong, and it can. Sometimes it's not your fault. Other times it is your oversight or someone else in your organization and you are kicking yourself. You didn't get the right visa, or you got shut out of the country in which your clients are based. You said something on stage that upset an audience member. Your reputation is tarnished by someone in your organization who suggests that your credentials and expertise are not accurate. Whatever the reason for the complaint, having systems and processes in place to deal with them quickly is so important. Legal action in court can be costly and expensive, and it may not produce a satisfactory result. It's almost inevitably better to negotiate a solution using your rights as a kind of bargaining chip. You do not want to get into an expensive, drawn-out dispute. People who go to court as a matter of principle are just not reasonable people, and they can cost everyone more time, more money, and more energy because they don't want a win-win solution for everyone. Believe me, however much you think you want to defend yourself, your rights, and your pride, you do not want your day in court. It's not an episode of Suits. No one is going to find a loophole to trip the other person up and have this finished in 3 days. No one wants to get one over on the other person. So this video is about how to avoid court as much as possible. Usually there are 2 types of claims that I see. One, someone has suffered a loss. This could be a physical, emotional, financial, or reputational loss. This is called a tort. This type of claim could be made against you or your business if you or someone working for you is negligent in something they do or something they don't do. If you misrepresent yourself or your products and services, or if you cause somebody a physical injury. For example, let's say that the sound man fails to put the speakers up properly at your event. They fall and they injure someone or a client, and wires are left out that someone trips over. These are the sorts of things that could cause a client to suffer a loss, a hurt, or a harm. This loss must be caused by the actions or inactions of you or someone representing you. Although I deal with a lot of people who hold events, I don't see many tort claims against speakers or trainers. But I want to mention this to you, because many events can have an emotional and physical impact on people. I think perhaps it's more likely that these claims come up in the US. Mostly the claims that I deal with are for a breach of agreement. Claims for breaches of agreement can vary. Let's take some examples. Mr. A was running a year-long mentoring program. He was asked for a refund long after he expected to pay out the refund to a participant on the program. The participant claimed that she had not received the full benefit of the program and decided to leave. But this was 6 months into the membership program. She was claiming 50% of the program fees back as a refund. Mr. A felt that it was unreasonable and unfair and offered a much lower amount, since she was not contractually entitled to any refund. In a second case, Miss B, we shall call her, met Mr. C. Mr. C passed all of Miss B's due diligence and was championed by large media and government agencies. Miss B therefore felt that she could trust this person and introduced Mr. C to her clients. He ended up taking a lot of money and the clients lost a lot of money. Miss B wanted to provide an outstanding customer service to her clients that had lost money. She offered to compensate them and their losses through another investment. although legally she had no legal responsibility to them, but she did feel a moral obligation. When the clients realised that Mr. C was not going to pay up, they turned on Miss B. They then went after her reputation by spreading rumours and writing false statements online. Miss B has not yet settled, and the clients received a warning letter for spreading these false and malicious information, but reputational damage was caused. Finally, Mr. D always provides a full and fair refund if requested, if you tell him that you are not totally satisfied. He stands by that promise and has never had a threat or complaint to my knowledge. These are just some of the examples that come up in practice. In each case, they have had a strong legal case, but when your reputation is at stake, you may be forced to negotiate a settlement just to draw a line under it. If you do receive a complaint from a client, then this is the process that you will go through, and it's an ideal course to follow when you do receive that complaint, even if you don't believe that it's your fault. So a client comes to you with a complaint about you or one of your staff in your business for something that they think has been done incorrectly, or they make a request that you feel is not fair and reasonable. Let's say they've changed their mind about a course that you sold to them. It's past the refund period, but they argue that they were on holiday until now and they're asking for a full refund. What do you do? So step 1, act quickly to find out more about the complaint or the request. From the very start, ask as many questions as possible to determine what is really going on here. If they say that something happened or that something was said, ask them for specifics. Now, don't get me wrong, this isn't about Spanish Inquisition, but do make notes and understand the specific details from their perspective. Do your best not to be emotional, and do your best to be alert when they're speaking. Don't interrupt them. You may not be the best person to speak to them if they are emotional, but someone from your business needs to find out the facts. What happened, who was there, what documents were involved, if they were injured, did they get treated? Ask them to send you documents and evidence so that you can go through it more fully later on, perhaps with a professional. For example, if it is a refund request, then find the document that they signed and read it. This is where it becomes important to have filed and stored your contracts correctly. What does the agreement specifically say in relation to this matter? Do they have a contractual right to a refund, or are they in a cooling off period where they are allowed to cancel? Depending upon the severity of the claim, ask witnesses to provide a short statement of the facts that might be useful. However, mostly when you deal with clients one-to-one, we know the issue because we're involved in it in some way and we already know whether they have a legitimate claim or not. If at this point you believe that they do have a claim, then you can move on to step 2, settle the claim. Integrity teaches us that if they are right, nip it in the bud, pay what you consider to be fair and reasonable. However, I do know that repaying a full refund may not be appropriate in all circumstances. Withholding some portion of payment for administration fees or cancellation fees are appropriate in certain instances. However, before you send that refund, wait until we've reached the settlement terms section of this video. Now, if a complaint is starting to escalate, it's time to move on to step 3. Start to put communication about this matter into writing. Whether it's a handwritten record made at the time of a telephone conversation or an email summary about the complaint to perhaps another member of your team, having it in writing is really important. If you don't agree with their claim in full, then the next thing to consider is whether this person is actually open to negotiation. This is step 4. Reasonable people are open to negotiation. Reasonable people will want to find a win-win solution. Unreasonable people will stomp their feet and tell you that they deserve what they deserve. They may even tell you how reasonable they are being. I have dealt with lots of people who are perfectly reasonable. They get upset, they get emotional, but they genuinely want a resolution that they feel they're comfortable with. I've also dealt with the other end of the spectrum. These people are delusional and all they want to do is to hurt you more and more. They are a different beast. One phrase you will hear me using often is that you cannot negotiate with crazy. What this means is that when people are emotional, they often cannot think reasonably. If they're upset by a matter, then this may not be the right time to have a logical conversation. They will not be able to see the wood for the trees. However, if they are open to negotiation and reaching a fair and reasonable settlement, then find out exactly what they would want. Take some time to think it over and work out how you could deliver what they want, but with it feeling like a win-win scenario. For example, you may be willing to refund more if they will accept payment over a longer period of time. If they need it all today, you may settle for a lower amount. I believe that you want to deal with your clients as honestly and fairly as possible. However, your idea of reasonable will naturally be different to your client in this circumstances. You do have to be careful with negotiation that all of your negotiations are subject to contract or without prejudice. Since if you're not able to come to an agreement, then the matter may need to go to court. So that brings us to step 5, the letter before action. If your client escalates the matter so that you receive a letter before action, then this is the point at which you might want to receive some legal advice or rethink your offer to them. This is like a stepping stone to them taking you to court, but this is not the court claim itself. However, if they do not have money or access to funds, then it is unlikely that they will be able to pay the court fee, and therefore they'll probably have to stop the claim at this stage. If you think that that is likely, then you may want to take the risk that they're not going to go to court. The fee for small claims, though, can be anything from £35 to 4.5% of the claim if it's over £10,000. Sometimes people are just not willing to pay the fees and therefore cannot start a claim. Always respond to a letter of claim, even if just to refute the facts. Whilst a lawyer is usually best placed to do that, you can take each paragraph and counter or oppose what's been said, or if it's true, then you can say that it's true. When writing this letter, don't get into the story. Set out the facts, set out the clauses, not how you felt or what you thought. Use cold, hard facts. I believe that the Citizens Advice Bureau or a pro bono unit will be useful to run the letter past, and they provide free support to individuals and small businesses. Step 6 is if you do receive the actual legal claim. The first thing to do is to keep calm and carry on, but don't bury your head. The small claims procedure is actually very simple. Anyone who's owed money can complete a form at Money Claim Online. Although this means that people can go to court quite easily, the fee acts as some form of financial hurdle. You have to be pretty determined to spend £400 when you can't guarantee that you will receive your money back. I took my landlord to court, well, the small claims court, when I was 20 years old, and we won our deposit back plus costs. The procedure was really simple, and it's specifically designed to allow non-lawyers to complete the process. It is explained more at my favourite website, gov.uk. Go to the money and tax, and then court claims, debt and bankruptcy, and then go for make a claim money online. This sets out your options, how to navigate the procedure, and will guide you through the process if you need it. Although you can negotiate at any point, when the court papers arrive on your doorstep, it becomes a little more real. Step 7 is another perfect chance to see if you can negotiate. You may both be more willing to get to a solution and avoid what will have been up till now a little bit of hassle. By actually going to court and paying the court fee, you are sure that your client is ready to do battle, and so this is the time to perhaps have another conversation. If neither of you is willing to back down, or you feel as though you are being reasonable, then you may just want to let the dispute run its course. Or again, if they are reasonable, suggest that perhaps you both do some mediation with a trained specialist. Be under no illusion. Going to court can zap your energy and your finances. Even at the small claims level, there is a significant level of preparation to complete to get your defense and any counterclaim that you need together. So step 8, if at any stage you do manage to come to an agreement, it is imperative that you send them a settlement agreement. Something in writing that they agree to the details of the deal that you've struck, and it must have the dates and the times and the amounts within it. These terms are so important. I can't stress how important, because they truly force the other person to draw a line under the issue and say there is no more claim. Anytime these settlement terms come out, think of it as the end of a dispute. Anytime you refund or pay back any money to someone in any type of compensation, you must send them a settlement agreement. These settlement terms were tested in court by Miss B recently. One of her clients had demanded her £100 promise because she had not been 100% satisfied with her services. Miss B provided a settlement agreement, and once they were signed, paid the £100. The client then tried to sue Miss B in the small claims court, but Miss B won because she had a settlement agreement in place. Mr. A also settled with a settlement agreement. He felt that it was a fair and reasonable price, and it was far below the 50% membership fee, and it was provided as a goodwill gesture to his client. Well, on that happy note, that brings us to the end of this video and this series. I hope that the information you've received can be put to good use in growing your business and protecting yourself whilst providing these services. In this series, we've looked at providing services through one-to-ones, events, retreats, and membership programs. We looked at the terms of business that are important for us to put in place to provide those services. We've also looked at the mistakes not to make and the types of agreements that you will need for different types of events. My hope is that you can go away with an understanding of the documents required here and that the pitfalls are more obvious to you than before. As I said, there is so much more to know about this. This won't give you a law degree, but it is intended to give you some key actions to take immediately. Watch out for one more video where I'm going to walk you through how you can work with me and take the next step to protect your reputation as a consultant, speaker, advisor, or mentor. Plus, learn some more about protecting other areas of your business that you may not yet have considered in as much detail. I look forward to seeing you then.